Welcome to the 29th episode in the first season of Justice Center Weekly, from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and with me is lawyer James Manson. Last week, James took the case of Dr. Robin Francis to the Federal Court of Appeal on the issue of losing employment insurance benefits after being fired for refusing to take a novel COVID vaccine. Dr. Francis had cited religious reasons. James, how did it go?
Not very well, Kevin.
Oh, sorry to hear.
Yeah. I'm sorry to hear it too. It was a tough time in the Court of Appeal yesterday. Well, actually, as we're recording this now, I'm speaking to you on Friday, which is the day after the appeal hearing happened. So, what happened was the court dismissed my client's application. And that's basically the end of the line for the Federal Court of Appeal. So it was particularly confusing to me because not only did they dismiss the appeal, they dismissed the appeal immediately. And when I say immediately, I mean exactly that. They dismissed the appeal. I'm sorry, I keep saying appeal. Mm-hmm. Technically speaking, we're talking about an application for judicial review. Okay. And this is a different kind of hearing. It's very similar to an appeal in some ways. You've got a panel of 3 judges that are hearing my pitch. And basically what I was trying to suggest was that the lower decision that we're talking about should have been overturned. So in some ways, it's like an appeal. And in that way, sometimes I just call it an appeal, but it's really an application. In any event, what was funny about it, and again, when I say funny, I don't mean funny. I mean confusing and concerning. But what happened was that not only did they dismiss the application immediately, they did it without even hearing the responding party, in this case, the Crown, the Attorney General of Canada. So that isn't a common occurrence, Kevin. Normally what happens is in a hearing, right, you hear the plaintiff, or in my case, the applicant, that's Dr. Francis. And in normal times, you will then hear the other side, the responding party, and they will make their pitch as to why the requested relief that I'm looking for should not be granted, right? Mm-hmm. Sometimes what happens is the court is totally unconvinced by the arguments made by the moving party or the appellant or the applicant in my case. And they don't even need to hear the other side because they think that the person that's making the pitch, in this case me, was so unpersuasive that it doesn't even matter what the other side says, because there's no way that I could win, that Mr. Francis, that Dr. Francis could win. And that's what happened. And I can tell you, Kevin, that's never happened to me before, ever in my years of practice. I have never, well, first of all, I like to say, in all modesty, I'm not going to bring a case to court that doesn't have a chance, that is totally spurious and vexatious and without any merit at all. I'm not going to do that. That's not my job as a lawyer, as a barrister, right, as an officer of the court. But in this case, the Federal Court of Appeal seemed to have absolutely no time for any of my arguments with respect to Dr. Francis's case. And I find that very, very concerning, because part of the case, a large part of the case, as the viewers know, dealt with the application of the Charter of Rights, in this case. As you said earlier in your intro, Dr. Francis had a problem with taking the COVID vaccine back in the day, a couple of years ago. And he did that because he's a religious person, and he had religious objections to doing it. And he even filed an affidavit with his employer to say that, asking them for an exemption from the mandate, from the policy, which they totally ignored. And he had other issues as well with respect to taking medical treatment that he wasn't really sure about. And that's also protected by Section 7 of our charter, which is the right to security of the person. And so, anyway, this case definitely engaged the charter. And whether or not you can lose your EI benefits because you're standing up for your freedom of religion or your freedom of bodily integrity. And the issue sort of revolved around, does the charter even apply in a case like this? So when you're talking about employment insurance benefits, as we've already mentioned, Kevin, we've already discussed this, I think, in a previous podcast, but
True, yeah.
there is this idea of misconduct under the employment insurance program. And so basically, we know and we accept as Canadians that sometimes the things that you do as a worker to get you fired, sometimes those are not appropriate things. And sometimes you will forfeit your rights to EI benefits because of how you get fired. If you come to work drunk all the time, if you're, using horrible language, at work, if you're harassing people, if you're coming to work late all the time, all of these things are normal and reasonable ways that you'll lose your benefits. But when it comes to your fundamental rights and freedoms, one of my arguments was, that's a completely different ball of wax. That's a completely different situation. And how can it be misconduct under the EI rules for a person to stand up for his rights and say, no, I can't take the vaccine because my religion compels me not to? And really what happened was the Federal Court of Appeal yesterday simply said, we're not going to get involved. We're just going to leave the decision by the lower tribunal, by the tribunals, as it is, and we're not going to get involved. Now, this is where the application versus appeal technicality comes into play. So when you're talking about an application like this particular type of court mechanism does focus on, generally speaking, it focuses on reasonableness of the decision. It doesn't necessarily always mean that there has to be a right or a wrong decision, as long as the decision is, quote, reasonable, meaning that there's many ways to skin a cat, and as long as it's kind of in the ballpark, they're not going to really get involved. And again, that's okay. I'm not taking an issue with that standard, because there's so many administrative decisions out there by so many different tribunals that it would be impossible for the courts to literally oversee each and every one. As long as things are in the ballpark, generally that's okay. But again, we're talking about the Charter of Rights here. We're talking about the Constitution. And in my view, that is a completely different situation. And in that respect, we need to change that standard from reasonableness to what they say is correctness, which means that there is a right or a wrong answer. And the answer ought to be that the Charter of Rights must take priority here. At least it needs to be balanced against the idea of firing people for misconduct, and then what happens to your EI benefits. So anyway, bottom line, Kevin, is that the Federal Court of Appeal basically decided we're not going to touch this. We're not interested in talking about the charter. We're not interested in talking about how that may intersect with the EI program. And we're not interested in the situation where, like Dr. Francis, sometimes there's a policy. I mean, look at the last few years, Kevin, right? We've had lots of policies that have invaded people's fundamental rights. And so the court wasn't interested. And so what happened was, I gave my pitch. It was about an hour or so long. And the court then rose for its morning break. The respondent was getting ready to, make her pitch. And then we were informed from the court that they needed an extra half an hour. And then they wanted an extra 20 minutes and then an extra 10 minutes. And so, of course, lawyers who have enough experience with this kind of are able to see the writing on the wall, which is to say that, either there's something really going on personally back there with one of the judges and they need time personally, or they're finding a way to dismiss the case out of hand. And that's what happened. And so they came back in at about 12 or 12:30 yesterday afternoon, and they orally pronounced the judgment without hearing the responding party. And so what happened was, again, they just basically went through some of the arguments that I had made, and they kind of just dismissed them out of hand. And so we'll be getting a copy of those oral reasons in a matter of days, I would imagine, and that's where it is. So I was very surprised, Kevin. I was disappointed. I'm still disappointed. I'm still very confused at how literally none of my arguments, which, again, in all modesty, these were good arguments. These were reasonable arguments. These were, courts, in my opinion, ought to be interested in the intersection of the charter with any other area of law. This is the supreme law of the land, right? And this is very fundamental stuff. I'm not sure why the court decided to disregard, I don't know if that's the right word. They just didn't want to engage. And it was difficult.
Did they explain why they didn't want to engage? That's what
the reasons, the reasons, Kevin, were fairly brief. I would say that, the president of the court, her name was Justice Woods. Justice Woods pronounced the judgment. And it might have taken her between 5 and 10 minutes to pronounce the judgment. So that much talking, when that's reduced to paper, probably 5 or 7 or 8 pages of printed, language. So really, no, there wasn't much analysis. And again, this is, I think, what is most disappointing to me. I am not expecting, Kevin, to win the day every time I go to court. That is not the life of a barrister. We expect to lose as much as we expect to win. Nobody can win all the time. Particularly, when you're acting for the little guys, in this case, against the government, you're not going to win all the time. And constitutional matters are hard, right? But you expect at least the court to engage with the issues, and you expect them to grapple and struggle with these things. And I'm not saying that they didn't. Maybe they struggled with all of this beforehand. The first thing that happens, Kevin, right, is you send in your written brief, and then the responding party sends in their written brief, and then the judges get to read all of that before the hearing. So they're generally pretty aware of the arguments before you come into the courtroom. So that might have happened. They may have grappled with it behind the scenes before the hearing, and they might have fleshed all that out. And they may have said, "Look, Mr. Manson, James didn't do anything to turn our heads at the hearing, so we're just going to let that go." That happens, quite a bit. A good barrister, a good lawyer knows that before you get into court, generally speaking, the judges have made up their minds already. It's not to say that they aren't open, but generally speaking, the written argument is usually more persuasive than the oral argument. But nonetheless, I didn't, by the way the judgment was pronounced, I didn't feel satisfied yesterday. Now I'm going to, read the judgment, a few times when it comes to us. Perhaps there's stuff in there that I missed, but I didn't really get a sense of, real earnest engagement from the court. And again, this should be of concern to all Canadians, because it's not about vaccines. It's not about the EI program even. It's really about tackling these issues, these important issues that are talking about the Charter of Rights. In this case, yes, it's about EI, but it could be about anything. And if I'm going to put in hundreds of hours, dozens of hours, hundreds of hours into a file, I would like the court to at least engage with me on those issues. I would think that would be appropriate. This is what I would think judges sign up to become judges to do, is to uphold the Constitution and to uphold our legal system. And I understand that, this is, again, an application where they were talking about reasonableness. And so there's many ways to get to the result. And it's not, if it isn't egregious, then it's not a problem. But how is it not egregious? You've got a man who cannot take a vaccine because of his religion, something that we cherish in this country, the freedom of religion. And he not only was fired for it, that's a different issue, but he doesn't get his EI benefits. I mean, this is something that everybody pays into, right? On the assumption, on the expectation that when things go south for you in your job, you're going to get some help from the government. That's the whole point of the program. And remembering as well, Kevin, Parliament passed this law, right, years ago. And they said in the law, they said, look, if you are guilty of misconduct, you don't get your benefits. But they never said what misconduct means. They never defined it.
Right.
And so what happened was that is left to the courts to interpret that word, misconduct. What does it mean? What's the test? How do you know if you've committed misconduct? And the Federal Court of Appeal, the very same court that I was before yesterday, is the one that was responsible for really fleshing out this test over the years. And so they're the ones who would be best situated to reconsider what happens when charter rights are at stake. Because again, like I said a few minutes ago, most of the time, right, Kevin, employers aren't violating people's charter rights. Thank goodness. Most of the time, the policies from your employer are pretty normal. They don't involve you taking a medical treatment or going against your religion. But again, sometimes they do, because they have in the last few years. And so now what happens? And so my argument again yesterday was, well, the charter has to get in somehow. It has to. But again, the court wasn't interested. And so again, just to finish my long thought here, I was disappointed that I didn't see more engagement on those issues, because I think Canadians would really want to know, why don't their charter rights now seem to matter when they're applying for EI? I'm not happy with that decision.
Yeah, it doesn't sound very satisfying. You were familiar with the government's position because they submitted their written arguments. In your remembrance of the judgment, did they seem to take into account those arguments, even though they weren't presented in court? Did it seem like they had some persuasive value?
My recollection of the situation, Kevin, is no, it didn't really go there. It was more, again, this reasonableness idea that I'm talking about.
Mm.
The court just threw the ball back, right? The court didn't want to engage with the ball, really. Now, just for what it's worth, the Crown's argument was basically, look, you shouldn't touch the tribunal's decision in this case. It was reasonable. It was fine. And she was right when she said, this is the tribunal member who started this whole thing for us. She basically said that the charter doesn't apply to the question of whether somebody has made misconduct, that the charter doesn't even apply. Technically, I could get into it, but let's not bore everybody with it. Basically, she said that the charter doesn't apply, and this Federal Court of Appeal agreed with that. And so again, you have a whole now collection, a whole subset of administrative cases, administrative types of decisions. Again, did you commit misconduct? Are you forfeiting your EI rights, benefits? At the moment, that is not able to be reviewed on charter grounds. If you say, excuse me, if you say, I'm Jewish and my employer is making me, eat a ham sandwich every day for lunch in the cafeteria, and I can't because I'm Jewish. But that's his policy. And I know about the policy, and I'm deliberately refusing the policy because I'm Jewish. I can't do it. Not only can he fire you, but you won't get your benefits. There's no difference. And I have no idea. I have no idea how that makes any sense.
Well, I understand the charter applies as soon as the government is involved. They're the
It
ones making the
should.
EI decision.
It should.
And so they're kind of backing it up to the employer's decision and kind of skipping over the fact that they're responsible for the decision. At least it seems to me that they're responsible for that decision about the government's portion of insurance. And I'm sure this is going to come up again, or it might have already come up in another case. I don't know. But it seems to me they should at least explain why, the government here in this instance is not, doesn't have to adhere to the charter. And did they do that in the judgment? I haven't seen it yet. No.
No,
Okay.
I don't want to overstate things because again, I'll need to read it again. I mean, I was a little bit surprised when they were pronouncing everything, and one of my colleagues was taking notes about the judgment itself. But no, there wasn't really much. There wasn't really much explanation in the sense that usually, right, when you're talking about arguments like this, there will be quite an analysis from the court about prior precedents and how we got to where we are with the law and why my argument to change it is not a good idea, right? That's what you're expecting. Here's how we got here. Here's the history of this situation of the law here. Here are the facts. Here is what Dr. Francis wants. Here's why I say it's a good idea. Here's why the Crown says it's a bad idea. And here's what we think. That's a fairly standard type analysis that a court will do. I don't remember them doing anything like that at all. It was basically just throwing the ball back. And that's it. So
well, now that you have the ball, is there anything you can do with it? Is there a recourse here?
Well, the only thing we could do now is to try to take this to the Supreme Court of Canada. That's the last stop. The last stop of the courts anyway. So basically what we've got here is a situation where we would now need to get permission from the Supreme Court to take the case to Ottawa. So basically we would have to file an application, some kind of a legal document that basically asks the Supreme Court of Canada to hear the case and tries to explain to them why they should hear the case. Why is this important? I mean, you can appreciate, Kevin, that the Supreme Court of Canada only hears cases that are of very, very significant importance to the country as a whole. And there are some ways where they will hear an appeal by right. So, for example, if you've committed first degree murder, for example, is one of the ways that you can go to the Supreme Court of Canada as of right, because it's such a serious situation. But there aren't too many of those. And normally you have to go and get permission, what they call leave to the Supreme Court. So we may do that. We may do that. I have to say, it's odd, Kevin, to talk about actually trying to get leave to the Supreme Court, because that hardly ever happens. There's hardly ever a case that a reasonable lawyer would say to his client, this might actually have a shot at getting heard by the Supremes, because we just don't get cases that are so important that often. But this case might have a shot. And the reason why is because, again, the issue again is, how does the charter intersect with employment insurance, which is a national program? And what happens when somebody says, I can't follow a policy because it's bumping up against my rights? That's never been considered by the Supreme Court. The closest we've gotten is yesterday at the Federal Court of Appeal, and they weren't interested at all in the argument. And so Maybe the Supreme Court will. I don't know. I haven't even talked to my client about this, though. We're going to have discussions about whether he would be interested in taking it further. Um, there's a lot of stress involved with these things, right? And clients tend to live and die by these things. Of course they do. This is their lives we're talking about. I mean, to me, well, I have to say I do too a little bit. I mean, these cases are heavy. They're heavy. They're very heavy, and I just wish that I was just about to say I wish I could have done better for my client, Kevin, but I don't think that's the right sentiment. We did a great job. We did a great written brief. Shout out to Marty Moore, my colleague, for helping me with the legal brief yesterday. I'll tell you, Kevin. Yet a lawyer knows when they've done a good job or when they've left something on the field. Not to say that I'm the best lawyer in the world or anything like that, but I made all the points. And we answered all the questions, and my colleague was there with me, helping me out, and we did everything we could do. And it just feels a bit odd not to get the level of engagement that you were expecting.
Yeah, as speaking as just a Canadian citizen, it would be helpful to know for me which branches of the government are subject to the charter and which are not, because my understanding to this point was that all branches of government are subject to the charter and that private
Of
business
course
are
they
subject
are.
to human rights legislation.
Of course they are. I mean, at least on paper, they are.
Yeah.
When you go to law school, there is no carve out for various departments. There may be exceptions like, again, the Section 1 test, right? For example, where maybe there's a reasonable limit on somebody's rights and freedoms. But we were not talking about that yesterday, right? Just so that everybody remembers. This was not about challenging a law. This was about challenging a administrative decision made by an authority, a tribunal. So the Section 1 Oakes test, all that doesn't apply. It's a different type of consideration. It kind of gets to the same in the end. It's balancing the charter versus the interests at stake from all around,
Right.
giving it a proportional balance, which is generally reasonable. But anyway, no, there's no carve out for different departments.
Oh, okay. Well,
and
like
I well, there shouldn't be. Anyway, the other thing though, Kevin, just right. The other thing that might happen would be a political solution. Certainly Parliament passed this law. Parliament can change it. And if Parliament changes it, then everything that the Federal Court of Appeal has done over the last, several years could be canceled, could be immediately overruled. It could be modified. It would not take much for a new government, shall we say, to say, look, this is unacceptable. The Charter of Rights will apply, period. And whether or not it always will carry the day is a different issue, but it will certainly apply to the sense that you have to consider it.
Right.
Right. Again, this is part of the nuance, right? It doesn't mean that you have untrammeled freedom of religion, right? If like the often quoted example is freedom of religion doesn't mean that you can have a human sacrifice, for example, right? That would be obviously too far. There's a limit on that, right? So it doesn't mean that your freedoms will always carry the day, but they do have to be considered. And so what I'm seeing is Parliament could easily say in the misconduct section of that law, misconduct involves, or the issue of misconduct must consider charter rights or charter values, in relation to the conduct that is complained about, whatever, something like that, which would signal very clearly to the courts that they need to do that. So this is the interesting thing, Kevin, right? That I'm starting to see, as I do more of this work here in the constitutional space. Back when we were in university long ago, me and my colleagues, we would hear a lot about this concept between the Parliament and the Supreme Court. So back about 15, 20 years ago, the charter was newer, it was younger, and the courts were engaged in interpreting lots of these rights. What do they mean? What do they not mean? What are the parameters of all these rights? And the concept was a dialogue, that there was a dialogue between Parliament and the Supreme Court, and they would formally speak to each other back and forth through judgments and laws. So the Parliament would pass a law, or maybe a legislature would pass a law, but anyway, they'd pass a law, and then the Supreme Court would essentially comment on that law as to whether or not that law was too broad, not broad enough, whether it was okay or not okay. And through that dialogue, we got a lot of good information about what the rights in the charter meant. But it seems to me, Kevin, that over the last number of years anyway, that dialogue has stopped. There doesn't seem to be much dialogue going on now between Parliament or the court. I mean, witness yesterday. I didn't get much dialogue from the court yesterday. I got kind of a bit of a shrug of the shoulders, really. And I don't think that that's appropriate. And on the other hand, can anybody really say that over the last 7 or 8 years, we've been having a cogent dialogue from the Parliament in terms of what our rights mean? What, I other than maybe platitudes from the executive branch, I think you all know who I'm talking about. There doesn't seem to be much substantive dialogue between the court and the Parliament anymore. And I think that that's a problem. And I think that's a shame. So, look, we could go to the Supreme Court. We could try to lobby Parliament. Maybe if there's some conservative MPs or some liberal MPs or any MPs listening to this podcast, maybe they could, give me a call or read the judgment, inform yourselves about what's happened here, because this is not right. At the end of the day, it's just not right for people to stand up for their rights and then lose their benefits. That's not why they pay into EI. That's not why they're made to pay into EI. You know what I mean? Most people don't have a choice, right? So right. Yeah. It's just not right. Okay. And I'm not sure what we do, but look, we're not going to stop fighting, obviously. And thanks to all the donors, and we're going to keep going. And your support is extremely, extremely appreciated. And know that it's not being squandered. It's not being wasted. We are doing this. We are doing the best we can. Right now, it's heavy seas. But we will eventually get over this, right?
Righto. Okay, James, thanks so much for taking the time to explain this to us, and I thank you for being here.
Thanks, Kevin.
And now I guess we'll take a moment for my special announcement. The Justice Center podcasts will be on hiatus for a while as we revamp, retool, and refresh. We're taking a break after 4 eventful years, starting back in January of 2020 with the audio podcast Justice with John Carpe. And this year, of course, we added our Justice Center Weekly video segment. Our next season for both will start in the new year. Before that, we will, I hope, get out 1 or 2 episodes in December, taking a look back at the events of this year, and maybe even as far back as our humble beginnings. I want to thank you, our audience, for tuning in, and I want to thank all my colleagues, the hardworking lawyers and support staff, who have given their time to the show. And of course, a big thank you to the Justice Center donors, as they will continue to make the important work of the Center, including these conversations about our constitutional rights and freedoms, available to all Canadians. We will talk to you again soon.